to 1974, was a prominent 20th century leader of American politics and law. Elected California governor in 1942, Warren secured major reform legislation during his 3 terms in office. After failing to claim the Republican nomination for the presidency, he was appointed to 14th Chief Justice of the U.S. Supreme Court in 1953. The landmark case of his tenure was Brown v. Board of Education of Topeka, 1954, in which the court unanimously determined the segregation of schools to be unconstitutional. The Warren Court also sought electoral reforms, equality in criminal justice, and the defense of human rights before its Chief Justice retired in 1969. Warren, born and raised in California, was elected District Attorney of Alameda County in 1925, California Attorney General in 1938, and Governor in 1942. In 3 terms as governor, he recognized the state's government and secured major reform legislation, modernizing the state's hospital system, prisons, and highways, and expanding old age and unemployment benefits. In 1953, President Eisenhower appointed him the 40th Chief Justice of the United States. He retired in 1969. There have been 2 great creative periods in American public law. During the first, the Marshall Court laid down the foundations of the American system. During the second, the Warren era, the court rewrote much of the corpus of constitutional law. Warren was the leader in his coursework, actively exercising his authority to reach the results he favored. In terms of creative impact, Warren's tenure can be compared only with that of Marshall. As a successful chief executive, Warren developed leadership abilities that enable him to guide his court effectively. His fellow justices all stressed his forceful leadership, particularly at the conferences where cases are discussed and decided. Justice William O. Douglas ranked him with John Marshall and Carl Evan Hughes as our 3 greatest chief justices. Those behind the impeach Earl Warren movement were correct in considering him the prime mover in the Warren Court's jurisprudence. Whitney v. California was a United States Supreme Court decision 1927, upholding the conviction of an individual who had engaged in speech that raised a threat to society. The background is Carriot Anita Whitney, a member of a distinguished California family, was convicted under the 1919 California Criminal Syndicalism Act for allegedly helping to establish the Communist Labor Party of America, a group charged by the states with teaching the violent overthrow the government. Whitney denied that it had been the intention of her or other organizers for the party to become an instrument of violence. Carol Anita Whitney, a member of a Communist Labor Party of California, were prosecuted under the state's Criminal Syndicalism Act. The act prohibited advocating, teaching, or aiding the commission of a crime, including terrorism, as a means of accomplishing a change in industrial ownership or effecting any political change. In an anonymous decision, the court sustained Whitney's conviction and held that the act did not violate the Constitution. The court found that the act violated neither the Due Process Clause nor the Equal Protection Clause, and that freedom of speech guaranteed by the First Amendment was not an absolute right. The court argued that the state may punish those who abuse their freedom by utterances, tending to endanger the foundations of organized government and threaten its overthrow by unlawful means, and was not open to question. The decision is most notable for concurring opinion written by Justice Brandeis, in which he argued that only clear present and imminent threats of serious evils could justify suppression of speech. The question before the court was whether the 1990 Criminal Syndicalism Act of California violated the 14th Amendment's Due Process Clause and Equal Protection Clause. The court anonymously upheld the Whitney conviction. Justice Sanford wrote the 7-justice majority opinion and evoked the Holmes test of clear and present danger, but also went further. The court held that the states, in exercise of each police power, has the power to punish those who abuse their rights to freedom of speech by adherence inimical to the public welfare, tending to incite crime, disturb the public peace, or endanger the foundations of organized government and threaten its overthrow. In those words with the bad tendency can be punished. It was be the decision. The case of Escobedo v. Illinois took place on April 29th of 1964. The Escobedo v. Illinois trial dealt with administrative law. This legal field revolved around the events and circumstances in which the government of the U.S. engages its citizens, including those instances where agencies are created and the establishment of federal standards. Danny Escobedo claimed that the police department in the state of Illinois did not adhere to the Due Process Clause of the United States Constitution. In Escobedo v. Illinois, Danny Escobedo claimed the police department unfairly questioned him without allowing him to contact a legal professional. Although Danny Escobedo requested an attorney, he was denied his rights to meet with legal professional until the end of the arrest process. While being investigated, the Illinois Police Department deemed the Escobedo indirectly admitted to the murder. In response to the way they handled the questioning, Escobedo maintained that both his 5th and 6th Amendment rights has been violated. The Escobedo v. Illinois case was decided on June 22, 1964.